With the Senate Judiciary Committee now seemingly determined to vote on Brett Kavanaugh and vote by Friday morning, or at least beginning Friday morning, criticism by the president about the allegations made in the New Yorker by Deborah Ramirez have ramped up. He spoke today about her drinking and what he called time lapses. As you know, Ronan Farrow and Jane Mayer of the New Yorker reported Sunday that Ms. Ramirez, who attended Yale with Judge Kavanaugh, says she remembers him exposing himself to her at a dormitory party. He denies it. We should also point out here that Republican staffers on the Senate Judiciary Committee spoke today on a conference call with Judge Kavanaugh, who again denied the allegations. Democratic staffers were also on the call but asked no questions. That's according to sources familiar with the call. Now, with all that said, here's my conversation, which we recorded just before airtime with John Clune, attorney for Deborah Ramirez. Mr. Clune, you heard what President Trump said about your client. I'm wondering, first of all, what your reaction was to that today.
Well, it's obviously disappointing to have anybody take an attack on your client, but I feel like the politicians are going to say what they want to say, but it doesn't mean that what Debbie disclosed is not true.
What is the current status of any discussions or negotiations you've had with the Senate Judiciary Committee? Because as recently as a few hours ago, Chairman Grassley said that Ms. Ramirez's legal team was just referring the committee to the New Yorker article and giving no other comment. And he also said, and I'm quoting, if Ms. Ramirez submits testimony and evidence to the Senate Judiciary Committee, which committee investigators have requested, we can decide how to proceed.
Yeah, I don't know where the senator is getting that information from. We've had a number of email communications with the committee so far, but the difficulty is every time we try to set up a phone call, the majority party either changes the rules of the phone call or they want additional information as a condition of even having a phone call with us. We finally had a phone call scheduled for 7 o'clock Eastern this evening. We got on the phone and only the minority party showed. So it feels like there's a lot of game playing that's going on right now by the majority party, and we just want to be able to talk to them and find out what is it they're contemplating about how this would be investigated or how Debbie could provide for information to the Senate.
When you said they're changing the rules of the phone call or how to set up the phone, can you be more specific?
Sure. So, for example, we had a phone call scheduled, and then they sent us an email and saying, for a condition for us to even have the phone call, you need to give us a list of all the evidence that you have and break it down for us before we'll even talk to you by the phone. And, we responded, obviously, saying, well, we're really concerned. We have a client that we want to protect. And, we want to make sure that whatever process you're going to do is going to be fair and respectful of her. And then they don't have the phone call with us. So I don't know what else we can do if they're not going to engage. But blaming us for being non-cooperative is just, flat out not consistent with how things have gone and what the emails show.
So just regarding what Grassley, the direct quote that he said, that if Ms. Ramirez submits testimony and evidence to the Senate Judiciary Committee, which committee investigators have requested, we can decide how to proceed. You're saying your client is willing to do that if you can, guarantee or get information in advance about the questions, or what specifically?
Well, no, I think the first thing that's critical, Anderson, is that this has to be investigated by meaningful law enforcement. This is not something that can be done by either the Senate or some hired gun prosecutor that wants to cross-examine, either Ms. Ford or Ms. Ramirez. This has to be done by FBI, who can investigate the matter with a threat of perjury. Our client's willing to do that. I'd be very interested to see whichever witnesses Judge Kavanaugh actually has remaining who are willing to talk, if they would be willing to do the same thing. So if we can get a meaningful investigation by the FBI, there are all sorts of ways that our client would be willing to provide information to the Senate.
So if there is no FBI investigation and it was just a matter of submitting testimony and evidence to the Senate Judiciary Committee, to committee investigators, that's not something you are recommending your client do?
I wouldn't recommend that she do that, no. I mean, that's if it's just a matter of her disclosing information to them, that would be one thing. But if they're intending to have either, grilling from the senators or grilling from some other individual, that kind of cross-examination cannot be a replacement for a meaningful investigation.
As you know, Senator Grassley, again, has raised the idea that, talking to the New Yorker, you can lie to reporters. Talking to Senate investigators is under oath. The implication, obviously, being that your client doesn't want to talk to investigators because it's under oath.
Well, that's belied by the fact that she has stated very publicly that she's willing to be investigated and actually tell her information to the FBI, which is also something that is punishable by the penalty of perjury. So an FBI individual, somebody who is a trained law enforcement investigator, somebody who is trauma-informed, somebody who understands sexual assault investigations, and certainly can't be replaced by the individuals on the committee or any staff members that they hire.
Would there be any advantage to having a preliminary interview, your client giving a preliminary interview to Senate investigators, and then hoping that that would spark an FBI investigation?
I don't know, maybe. If we could get the majority party on the phone to actually talk about these things, we'd be a lot better position to consider these things and talk about them with our client. But right now we can't get any information from them.
So they literally were not on the phone call that you had scheduled?
Correct. The minority party was there and the majority party did not show.
One of the suspicions that's been raised, obviously, about your client, which I want you to be able to respond to, is that it took Ms. Ramirez 6 days after she first talked to the New Yorker to actually name Brett Kavanaugh as the person who allegedly exposed himself to her. And that she consulted with attorneys. I'm not sure if it was with you directly. Can you explain why it took her 6 days?
Yeah, it was not with me directly. It was with another attorney. But, the interesting thing about Ms. Ramirez is she is very, very careful and very deliberate that she's not putting information out there. She realizes the gravity of the situation in which she's coming forward. And so she wanted to be very, very careful. It's 35 years old. She wanted to make sure that what she was actually going to be disclosing publicly was information that she could rely on and that she could stand by and that was accurate. With that passage of time, she went through those memories, and there were some things that she believed were probably true, but she didn't disclose those because she wasn't completely convinced of their accuracy. So that's the only reason why she did the work with the attorney and spent the 6 days to make sure that that information she did put forward was indeed accurate.
Some people have implied that perhaps the attorneys she spoke to may have been politically motivated or politically connected and encouraged her to specifically cite Judge Kavanaugh, even though her memory was not full on that. And last night on Fox News, Judge Kavanaugh cited a New York Times report that said Ms. Ramirez had recently contacted former Yale classmates, told some of them that she wasn't sure it was Kavanaugh. Is that true that she had done that?
I wasn't representing her at the time that was going on, so I wouldn't be able to answer that question. But in regards to the information about the attorney that she hired Stan Garnett, who is a career prosecutor. He is somebody who, just so very recently, was the elected district attorney for Boulder County, Ms. Ramirez's home county. So he was the perfect fit. And for anybody who knows Mr. Garnett, there is no way that he would play politics with some sort of information like this. He cares about victims of sexual violence, and he wouldn't put forth information that was not accurate.
And just so I'm clear, you're saying you have not asked your client whether, in fact, the New York Times reporting was correct, that she called up former Yale classmates and to some expressed that she wasn't sure if Kavanaugh was involved?
I haven't asked her about the information in the New York Times article, no.
If that, in fact, was true... sorry, go ahead.
Yeah. I mean, if that's true, it would be more evidence of the fact that she wanted to be very, very deliberate about what was being put forth. I mean, she is probably the most careful and conscientious client that I've ever represented. She is very adamant that she's not going to put forward information that she doesn't actually recall and doesn't think it's something that she can rely on. And to the extent that she was looking for any additional information, I mean, that was just smart investigation to make sure that, she wasn't remembering things inaccurately or by the passage of time.
Mr. Clune, I appreciate your time. Thank you.
Thanks, Anderson.
Well, about what you just heard from John Clune, that interview was taped right before we went on air, that no Republican staffers were on tonight's conference call. We asked Chairman Grassley's office to respond. We received a chain of emails. This chain of emails here, which goes back several days, got no direct answer to our question about no Republicans being on the call. I've just been going through this while we were playing that interview, and it seems like they're talking past each other. Mike Davis, a number of times, asked over the last several days, Mr. Clune, saying, before we discuss a phone call or any other next steps, we need to have the following information. One, does Ms. Ramirez have any other evidence, including other statements in addition to those that are contained in the New Yorker article? And two, is Ms. Ramirez willing to provide her evidence, including her testimony, to committee investigators? They're saying they want that before they discuss having a call. And repeatedly, also, Mr. Clune, in response, is basically saying, in response to the first question, there's certainly more witnesses in the article That's why we want an FBI investigation. We don't see how you can get to the root of the matter without that. As for your second question, we couldn't answer without learning more from you about the details of whatever process you are contemplating. After hearing more, we would advise the client accordingly, and she could decide. So they seem to be talking past each other on this.